Good morning, Judge Shapiro. I would like to let you know that we have the court reporter and both parties ready whenever you are.
Ready.
Okay. Good morning, everyone.
Good morning. Have we got everybody here?
Everybody's present.
All righty. All right, well, I'm going to call the case. This is, we're hearing the summary disposition motion here today on Genuine Solutions Counseling Center, PLLC, and Scott Hall versus Governor Gretchen Whitmer, State of Michigan, Mr. Feeney, Ms. Sampson, Ms. Massey, and there may be some other defendants listed here. And the case number is 21-185. And so it's defendant's motion. There are an awful lot of counts here. I went over this again this morning. And so if as you talk about them, it would be helpful to me, you don't have to search for it, but if you can recall who the named defendant was or were in the relevant count, because not all the defendants are in every count, and I'm trying to make sure I keep it straight. So who is here for the defense?
That would be me, Your Honor. Eric Grill, Assistant Attorney General.
You can proceed.
Thank you, Your Honor. I know the court has read the briefs. I will refrain from reciting the entirety of the healthcare provider's manual this morning. Looking at plaintiff's response, it seems like we're dealing with a much more narrow set of issues. It seems like the parties are in agreement that Governor Whitmer is out of this, as are all of the official capacity claims against the remaining defendants. So what we're left with are individual claims against Mr. Feeney, Ms. Massey, and Ms. Sampson. There's really no dispute here about any of the facts of the case. The parties certainly have their own perspective on the facts, but the actual events themselves are pretty well established in the record, and there's not a lot of divergence over what happened here and what transpired. Similarly, the law in the applicable here is well settled. And looking at plaintiff's response, there's not a giant divergence over what law applies here. Instead, what we're left with is a dispute between the parties over how the law applies to this case. So I think we're pretty well situated for summary disposition here. Turning to Mr. Feeney, right off the top, we can establish that Mr. Feeney is entitled to prosecutorial immunity. It's abundantly clear from both the complaint and the response that all of the actions that Mr. Feeney is alleged to have done here that would have caused any injury to Mr. Hall or to Genuine Solutions would have been done in Mr. Feeney's prosecutorial capacity. These are things that effectively the issue that we're talking about here is the decision to initiate charges, criminal charges against Mr. Hall. And while the plaintiff may dispute, may disagree, may strongly disagree with that decision, the fact remains is that Mr. Feeney, as a prosecutor, is entitled to absolute immunity for decisions arising from the decision to initiate or prosecute or present criminal cases. And that's it. That's binding law in Michigan under the Bischoff case, which is cited in our brief.
The plaintiff seems to argue that there was some investigatory responsibilities that Mr. Feeney had. Can you respond to that might fall outside?
Sure, Your Honor. What we talk about when we talk about investigatory capacities, it's not the idea that if the prosecutor engages in some part of the investigation that pierces or eliminates the immunity. Rather, it's the idea that if the prosecutor engages in investigative activities, their prosecutorial immunity may not protect them for acts taken in their investigatory capacity. So frequently where this comes up would be if a prosecutor presents an affidavit or to a court in order to seek a warrant that contains knowingly false statements. That type of activity, that's the courts have held, is not prosecutorial, even though it's interacting with the courts. That's part of the investigative phase, and that's where prosecutors tend to lose their prosecutorial hat. We don't have that here. There is no allegation in the complaint, and there's nothing in the response that anything that happened in the investigation violated any of the plaintiff's rights. There's not an aspect here that evidence was seized without a warrant or that witnesses were questioned without a lawyer present. It's rather the idea that they don't like the conclusions or they think the investigation could have been done better, but that doesn't give rise to a violation or tortious conduct. Looking at it another way, if we kind of go from start at the end and work backwards, if we take all of the initiation of charges after and take it out of the case, what happened during the investigation that Mr. Feeney or Genuine Solutions would have been able to bring a lawsuit about? An investigation could have been conducted, witnesses could be interviewed, documents gathered, all of that could have happened without ever giving any injury to Mr. Hall. The only thing that causes any injury is the ultimate initiation of charges, and that's where the prosecutorial immunity kicks in, and it's absolute.
Does that immunity apply also to claims of gross negligence and intentional tort?
It's absolute. It applies to both. And in fact, under federal law, to the extent that we're talking about the 1983 claims, the courts have held that even malicious conduct is covered by prosecutorial immunity. So it's pretty sweeping, it's broad, and it covers both intentional and negligent torts. So so that's prosecutorial immunity, and that takes care of Feeney entirely. If we got somehow beyond that, Feeney, of course, would still be entitled to qualified immunities under state law for both intentional and negligent torts under the framework that we've established. That would apply for both for Feeney, Massey, and Sampson together. The idea that, at least for intentional torts, that they have to be acting in their official capacity, engaged in a governmental function, and have a good faith belief that their actions were lawful. Now, there's been some talk in the plaintiff's response that the defendants, weren't acting in their authority because they were wrong. That's not really how that analysis works. Basically, you're looking at the actions they're performing and determining whether or not that's the thing that they're supposed to be doing. So in this case, you have a prosecutor and you have DHHS officials evaluating whether or not a healthcare provider is engaged in some type of misconduct related to Medicaid. Now, if they were doing something else, if they were investigating a drug buy or something, they'd be they'd be wandering outside of their official capacity, perhaps in that respect. But that's not what we have here. Similarly, we look when we're talking about a governmental function. What are we talking about? We're talking about the initiation of criminal charges. We're talking about the evaluation of whether or not somebody's participation in the Medicaid program should be suspended. Those are unquestionably governmental functions. This is not a situation where people are engaged in some type of lark or performing some side business. These are governmental functions, and these are officials performing the functions they are hired to do. So what we're left with is the analysis of is there a good faith belief? Were they acting in good faith when they engaged in the conduct? And what we have is the affidavits from each of them explaining why they did what they did, and it very clearly lays out that they were acting in good faith. When we're talking about Feeney, he lays out the investigation, how it developed, who he was talking to, what happened, what transpired that led him to dismiss the charges. There's nothing in there.
Yeah, let me interrupt again. I just want to be clear, because I found this a little confusing, which is, as I understand your position, and I'll ask the other side, is if prosecutorial immunity covers the actions of Mr. Feeney, we don't get to qualified immunity. Is that right?
That's correct, Your Honor. It's a backup. If in some circumstance we get past prosecutorial immunity, I want the court to know that Feeney still does have the protection of that, but I think that the analysis for Feeney stops at prosecutorial immunity.
Okay.
And then when we're talking,
if we wanted to continue, that's fine.
No, that's fine. And then when we're talking about Massey and Sampson, I think the situation is even more clear cut there. This was not a situation where they're making an independent determination that Mr. Hall and Genuine Solutions did something wrong. Their determination was based solely on the existence of those criminal charges, that, hey, there's these criminal charges, and that's in itself a reason that you should not be continuing to participate in the Medicaid program. And that's a perfectly good faith determination. Obviously, there's public interest at stake there. There's protection of the program itself. And Mr. Feeney, Hall and Sampson, Ms. Massey and Ms. Sampson explain their reasons. And in fact, for Ms. Massey, I believe she doesn't even do any analysis whatsoever. She's relying entirely on the analysis performed at the OAG by Ms. Sampson. So that's a good faith reliance. That's something they're allowed to do and that they're required to do. So, that's their good faith there to address any intentional tort, which would include defamation. Similarly, when we're talking about negligent torts, same analysis for the first part of it, where they're talking about these are government officials engaged in governmental activity. But then we get into whether or not this was gross negligence. And this is something that has to be affirmatively pled by the plaintiff in their complaint to say, this is why we think gross negligence has been met. The complaint is a little lacking on that point, Your Honor. And then what we see from the response and from the affidavits is there was no gross negligence here. Again, Mr. Hall and Genuine Solutions can disagree about the conclusions reached by Massey and Sampson. You can say like, well, it wasn't fair. They should have believed me. They should have listened to me. That's fine, but that doesn't mean that they were acting with reckless indifference to whether injury results. That's the threshold. It's very high, and we just don't have the facts that meet it.
Have any of the defendants been deposed to date?
No, Your Honor.
Okay. Do you want to say anything about the constitutional claims?
Sure, Your Honor. And in regards to the 1983 claims, when we're talking about qualified immunity, again, the defendants have to be aware that their conduct, is violating a clearly established constitutional right. And in the case law on that is very clear that when we talk about clearly established, it means something very specific, that there is basically existing law that addresses that the actual conduct at issue violates a constitutional right. So we have to have basically a case somewhere saying that a federal court has determined that when somebody does X, Y, and Z, that is a violation of a constitutional right. And we don't have that here. There has been no law cited by the plaintiffs establishing that any of the defendant's conduct here violates a clearly established right. What the response instead focuses on is the idea of, well, we wanted a better hearing. Well, that's fine, but there's no case law out there saying that that's what they're entitled to. And so when basically what it comes down to when we're talking about immunity is that if we have a situation that has never been dealt with before, a court may find that violates a constitutional right, but the first defendant, for lack of a better phrase, gets a get out of jail free card, that they would not have known at the time they engaged in the conduct that their conduct would violate a clearly established constitutional right, because it was not clearly established at the time that they did it. What the plaintiff would have to show here was that there was clear law in existence at the time that either Feeney initiated the charges or that Massey and Sampson did issue their respective orders on suspending the plaintiff's participation in the Medicaid program, that those actions violated clearly established constitutional rights. And we don't have that. There are no cases that say that. In that regard, the defendants then are entitled to qualified immunity under a long line of cases in the Sixth Circuit and in the U.S. Supreme Court. As it concerns the individual failure to state a claims for each of the various counts, I think that's very well laid out in the brief. I don't have a lot to add to it other than to say that when we're talking about the due process violations for Sampson and Massey, the problem what we run into there is that there was a hearing. First, we don't think that there is any actual property interest at stake, that that's not something that has been established, and the plaintiff has not established the law requiring it. The cases cited by the plaintiff's response refer to licensure, but this wasn't a licensure problem. Plaintiff's licenses were never suspended. They had their licenses all the way through. The only thing at issue was their ability to participate in and bill Medicaid. That's a different thing. That's a different animal. They could have been continuing their practice with cash over the counter or whatever other methodology. They just weren't allowed to bill Medicaid. That's not the same thing as having their license suspended. But even if you accepted the premise, and we don't, but even if you accepted the premise that there was a property issue at stake, there was notice and an opportunity to be heard. The plaintiffs were given notice of the pending suspensions, and there was a hearing. Hall, in fact, participated in a hearing, and he complained that the ALJ wasn't listening to him and wouldn't let him bring in various parts of evidence. But that's the hearing. That's what an ALJ is for. And the only determination there, as the ALJ stated, and this is stated in the plaintiff's response, was, well, are there criminal charges pending? Yes or no? And that, I think, underscores what the determination for Massey and Sampson was this was not an investigation independent of whether or not the billing was correct or not. This was simply, are there criminal charges pending? Yes, that's it. That's the basis for your suspension. So even if there was a property interest, there was notice and an opportunity to be heard. So there was due process observed. Similarly, when we're talking about the equal protection claim, there's no comparator. There's no one he's comparing himself to say that they were treated better or differently. There's no suspect classification here at all. This is not a situation where people of one race or gender or religious faith are treated preferentially. We don't have anyone he's comparing himself to. Instead, there's a promise that maybe in discovery we'll find someone, but that's not how this works. If we're going to state a claim for equal protection, we have to know who you're comparing yourself to, and that's just not here. And I think, I think that addresses all the constitutional claims. I think there was, to some extent, a seizure claim, but it falls for the same reason as the due process argument, which is that there is no property interest at stake, and certainly nothing was seized. They were allowed to continue practicing their counseling clinic in any other way. Just they couldn't bill in a particular way. That's far from a complete elimination of their ability to practice.
All right, thank you. And who's speaking for the plaintiffs?
William Savage on behalf of the plaintiffs, Your Honor.
Thank you. Mr. Savage, if you could begin with the prosecutorial immunity, that would be helpful.
Yeah, absolutely, Your Honor. So it's a complete mischaracterization of the law to state that because that the investigation immunity, qualified immunity, only applies to the investigation, portion of conduct, and then the absolute immunity applies to everything else. That's not how I read the case law. The case Metz, the court found that the prosecutor was not entitled to prosecutorial immunity, but was entitled only to qualified immunity. And
are you referring to a case? I didn't catch the name.
Yeah, I'm sorry. It's the West Michigan Film LLC versus Metz.
Okay, thanks.
That's METZ.
Okay.
But I mean, I'm sorry.
I said I cut you off, so you were going to tell me about what that.
Oh, yes. Yeah, I'm sorry. So, I mean, in that case, it was not that, they were accusing a prosecutor of misconduct during an investigation. They were accusing the prosecutor of everything, including the prosecution was all, misconduct. They were going after that. And I'll just say that it makes sense when you look at things under the law. An investigator has a bias that a prosecutor is not supposed to have. And so when you have two different levels of immunity, and the courts are trying to decide, well, which one applies to this person who did both the investigation and the prosecution, of course it should be the lesser immunity. And here, where defendants are stating that, well, there was no misconduct in investigation alleged. I mean, that's losing the big picture. For sure, that's getting lost in the forest, and that's or the trees, and not seeing the forest here. Misconduct is there was no crime. That's important to remember. There was no crime here. That is the one glaring issue that must not be swept under the rug. There was no crime here, and so the law does hold that if there is no crime, there is no qualified immunity, And so there should also be no prosecutorial immunity. And specifically, I'm thinking of a case, Leonard versus Robinson, which is a Sixth Circuit case, which involved an officer in, I forget where in Michigan, but an officer in Michigan was at a town hall meeting, and they arrested a civilian speaker who was called on to speak, and then they became kind of belligerent, and so they arrested him. And what the court said in Leonard was he was called on by the chair. He has free speech. Of course he could be speaking. He wasn't, the chair didn't, I'm sorry, I'm forgetting the term for, unrecognize him, but he had been recognized by the chair. And what the court said there absolutely applies here. And it's, you don't have probable cause if there's no crime. You don't have immunity if what you're doing actually doesn't relate to a crime. And not just that, oops, it turns out they weren't guilty of a crime, but where there is no crime at all. I mean, take your pick. I don't know, pick any ridiculous thing here. They charged and arrested him for, investigated and charged Mr. Hall, let's say, with something as ridiculous as, counseling people, over the age of 60 or something that's so clearly not a crime. There would be no probable cause for that, and there would be no immunity protections attached to that.
Mr. I think I follow this argument that you're making, but I also want you to, let's assume for a moment that the investigation charging distinction is significant. Is there anything Mr. Feeney did that you would characterize as falling within investigation or outside the normal activities of a prosecutor, putting aside that you believe that your client was charged with a crime that had no basis?
Yeah, absolutely, Your Honor. You can see from all of the investigation reports, right from the very first one, investigation report 01, Feeney's name is on it. He was obviously very involved with this investigation. He talks in his affidavit as if he was involved in the interviewing of witnesses. I suspect probably directly interviewing witnesses or sitting in on them. And that, as we can see from the case law that I cited, is actually sitting in with witnesses on that counts as participation enough to switch from prosecutorial immunity to the qualified immunity that an officer gets.
So what did he do in the investigation that was improper? In other words, if this crime had not been charged, would there have been anything that he did that would have been considered improper?
Right. So that is the entire investigation of a non-crime. You're actually, I'm hoping I cited and have in my brief the Leonard case, but that is essentially just arresting a person without probable cause for a non-crime would be that. And what the court held there is that that's because all the law enforcement is actually responsible to know the laws they're enforcing. And so what that means here is that before going through this investigation, getting I believe getting warrants to go in and search and take documents and all that stuff, because getting the warrants themselves would be a violation that would be the misconduct. Getting those, you need to have an actual underlying suspicion of a crime. That's where probable cause comes from, a suspicion of a crime. If there's no crime, then you can't have suspicion of the crime. Here, they've got the cart before the horse. They're saying, well, it turns out there wasn't a crime, but we thought there was. We suspected one, but that's just not good enough under the law. And we can see why. It obviously shouldn't be good enough. You can't have
without a charge. If he wasn't charged, I don't think I still don't think you've told me what would have been improper. I mean, things get investigated all the time.
Well, crimes get investigated.
Pardon me?
Sorry. Well, crimes get investigated. But Yes, so
I see the point you're making. Okay.
yeah, yeah, I think getting the warrants is, that counts as improper. That counts as and executing the warrants counts as a violation of constitutional rights. The search warrants, taking of documents, those violate the Fifth Amendment rights. And if you're involved in that from an investigation side, you're not entitled to the prosecutorial immunity. But I think the underlying kind of foundation of the complaint, the thing that's reiterated, and I apologize for reiterating it again, but the misconduct was anything that was done here where there is no crime. So any part of the investigation, prosecution, all of that, when there is no crime, becomes misconduct. And I don't mean to switch gears, hopefully too roughly here, but that goes straight to the point about existing law, there being no existing law, that the first person who's found to have violated a constitutional right gets kind of that get out of jail free card. Well, here it's much more kind of broader than that. The clearly established right is that you have a clearly established right to not be charged with a non-crime, and that's all in the Leonard versus Robinson line of cases. Those are federal cases dealing with and specifically the Leonard versus Robinson one is dealing with Michigan law, but either way, it's constitutional law, and it's yes, if it's something pretty much anything else, you have to have somebody who's done it first, and a court who said, hey, you actually are allowed to do X, Y, or Z. So that is a you violated their constitutional right. But here, there's kind of a blanket. If it's not a crime, if it's not a crime, you can't go after somebody for it. You cannot destroy their, their life, set them back hundreds of thousands of dollars in their business and all that stuff. And just kind of, oops, I didn't realize that specifically wasn't, labeled as a non-crime. And of course, because
And
that,
what is the, I'm sorry, I do recall the facts pretty well, but it would help me if you would say what was the non-crime? In other words, what was I remember that either the
Yes.
regulation said you can just be in contact periodically. I don't recall exactly.
Yes, yeah, exactly. So what the suspected crime was that he was having student interns conduct counseling, and then he was billing Medicaid for that. And the allegation is that you are required to be in the room with initially the allegation was that he was required to be in the room with the counselors, and then it turned into, well, actually, we've studied the rules a little bit better, and what he needs to do is have a weekly meeting where he educates them on their towards their bettering their counseling here. And of course his response was, but wait a minute, I have those weekly meetings, they're documented, there's no dispute as to that, I have those weekly meetings. And then they came back and said, yeah, but the interns really didn't think you were that helpful or something like that. And of course the interns are not the prosecutors. I don't think should be liable for a crime because your interns don't feel you were as helpful as you could be in your lesson plans or whatever. So that really didn't seem to hold much water. So
I'm jumping around a little bit here, but help me with Massey and Simpson or Sampson, whatever their name is. I'm having some trouble seeing what they did.
yeah, absolutely. So right. So as was seen in their affidavits, they were ultimately responsible for the suspension that happened. And as far as the kind of defense that, well, I was just following orders, that wasn't really the case here. They were responsible. The buck stopped with them. you could say.
They
So,
don't conduct their own investigation.
well, I mean, at some point, that seems like, that defense just it doesn't seem to cut it in the sense that there must be some, if it's just a rubber stamp, if that's what they're doing, just rubber stamping. I mean, you got to follow the trail back to somebody, I guess you could say. And here it's either they are responsible for making this decision and suspending somebody's license, or they are agents of Feeney. I'm not sure how else to say it, but I really think that this is something that falls under their department. They were responsible for seeing, okay, is this person, as they stated in their own words, we have a responsibility to see, is this person a danger to the Medicaid funds, basically, to that pool of money? Are they a danger of, kind of taking funds that they're not entitled to? And here the answer was obviously no, they did not violate your policies or your rules or regulations. And if anybody should know that, it would be, Massey and Sampson, who are high up in the Michigan Department of Health and Human Services, and they have this responsibility of, enforcing those rules and regulations. So when it comes back and the policy expert says, no way, this is not I can't support you in this, as here, there was a, sorry, I jumped a little bit. There was a,
I remember there was a new expert. Yeah.
okay. So that,
would you
I guess,
agree that for Sampson and Massey, you've got to show either intentional or gross negligence?
uh,
At least under the state claim.
Right, for the state claims, the 1983 claim, you brought up a good point I wanted to get to.
Sure.
Defense had stated that, that even, I don't want to misstate here, but something along the lines of even maliciousness has been held to not violate qualified immunity, or to upset the qualified immunity privilege, and that's really sorry.
I see. Yeah.
Just to be clear on it, that was specifically related to prosecutorial immunity under federal law. That wasn't about qualified immunity.
Oh, I'm sorry.
No, I'm sure that up. Okay.
Oh, okay. Well, I mean, either way, the 1983, claims are not a claim of maliciousness. They're the governing factor is, was this a violation of a constitutional right? Not, res mens rea. What were they thinking? Type of thing.
Right. And a clearly established one.
Okay,
but not
right.
not intent or negligence. I understand.
Right. Yeah. And so, sorry, just pulling up my notes.
Take your time.
So, as far as the, well, you have a right to a license, but you don't have a right to, essentially, how plaintiffs would phrase it is, you don't have a right to use that license. So, plaintiffs ran a business where their entire business was taking, in clients who were entitled to Medicaid, and then receiving funds from Medicaid. And when the suspensions hit and they were no longer allowed to do that, Plaintiff Hall took out a second mortgage on his house. They continued to see patients because they were afraid they would lose that business, that those people would go to other counseling centers. But they didn't start charging them. He essentially funded his own business through his personal funds. He started writing IOUs to his employees. So the idea that, well, yeah, you do have right to, your license, but not to, use the license or get the payments for the license. I think that's really splitting hairs, and I don't think that's fair. You know, I don't think that's in keeping with the spirit of the law as far as constitutional rights to, a property interest in your license to be a licensed counselor in the state of Michigan. And similarly with the, he did have a hearing, but I mean, so here's the problem with the hearing. It's like that fruit of the poisonous tree, but kind of in reverse here, where you have, sure, he had a hearing, but he was told, we're not here to decide if you are accused of a legitimate crime. We just want to know if you're accused of anything. I mean, plaintiffs, it's farcical. The idea that you could be, you got your due process because you had a hearing here, but at the hearing, you're actually told, well, no, we're not here to decide anything about, the legitimacy of the charges brought against you. We're just here to decide if we feel, that there were any charges, legitimate or illegitimate, brought against you. And so, again, that's another kind of, hey, I was just doing my job type argument. But here, the just doing my job does not include persecuting a non-crime. And it can never include that, and it should never include that. I think that kind of our whole criminal justice system goes off the rails when we start including that. And I think that on a higher level, and at least at the federal appellate level with the cases that I've cited, that answer is clear, that no, you can't have a non-crime and somebody gets their due process for being, dragged through the mud based on this non-crime and everything else.
Is there a hearing in the criminal case?
In the criminal case, I believe there was a waived like preliminary examination or something that was waived on bad advice from a defendant, a public defender, and then
Okay.
But just to be clear, I was referring to an administrative hearing when the just previous.
Oh, no, I know. I just wondered if there had been testimony taken that I might want to see, but it wasn't. Okay.
Yeah. And as far as the criminal, proceedings, this was something where, and this is alleged in the complaint from the very beginning, Mr. Hall was saying, I think these are the regulations you need to be looking at. They very clearly say I'm allowed to do this. And it was then over a year that the criminal proceedings continued without, with the first person on defendant's side to look at those regulations being the policy expert who was intended to be used as a witness at the trial of Mr. Hall. And so, again, I think I'm hammering that point pretty hard, but I think it's it is the underlying foundation of all of these kind of defenses here. I mean, you're yes, you have immunity for going after people for crimes. You don't for things that are not crimes, and that's again the same.
When you say for things that are not crimes, yeah, okay, I understand what you're saying. It's kind of it's a little bit.
It's
non-crime and not guilty of a crime.
Right. Yeah. The two, and I understand that it can be a pretty close shave there, the difference between them, but at the same time, I think it's just so vitally important, that distinction, and I think the law holds that that's vitally important. And so as far as the gross negligence count 5 claims go, I mean, I think I won't reiterate everything I've already said, but I think everything I've already said goes straight to gross negligence, that accusation. And And also, I know there's some disagreement between myself and the brother counsel here as to how to correctly plead negligence or gross negligence. But either way, negligence with a, I believe the gross negligence standard is met here. Obviously, if you're going after somebody for, something that's not a crime. And as far as the maliciousness, a major issue here, and this is, I don't want to be, flippant, but I think clearly there's a duty to double check before at least a year has passed by, whether or not what you're prosecuting or, suspending somebody for is a crime. It is actually a violation of the regulations as you say it is. And I think that's something we could expect, high schoolers who are put in this situation to do. Is this actually a violation? Like I say, it's a violation. And that analysis was not done for over a year. And in that time, so much damage was done. In fact, just currently, my clients reaching out to me, hey, can you help me? These people are healthcare network or whatever is refusing to deal with us. They're saying because we were suspended. And as just by way of background, that suspension was later rescinded, basically made null and void on account of the nolo prosecuti dismissal of the criminal prosecution. And yet it's still having the same effect as if it were in place today. It's still getting plaintiff denied. And so that's another major kind of theme here, is that this kind of no harm, no foul defense does not apply. You've got a lot of harm done, and in a very I'd say short amount of time, but it was actually over a year of the prosecution and so this isn't just a situation where you kind of put a band-aid on it. These are companies here that deal with was there any violation ever, and if I see that, I'm not going to deal with you, Mr. Hall, or deal with you, Genuine Solutions. And so there are just extensive damages. I'd like to remind the court of that. So I did also want to mention, you asked if there were any depositions taken, and there is the discovery deadline is not for, I believe, several months, maybe. Mr. Grill is more aware of that exact date, but either way, the intention was to conduct all these depositions after these motions were decided, after this kind of preliminary matter was decided. And I don't really want to reiterate my brief here, but I did want to just touch quickly on the issue of good faith. I know it was alleged that the affidavits meet the burden of good faith, and I very much do feel it is the defense's burden at this point, where these things were, again, the bad faith, I think, is shown by the fact that nobody looked any deeper than surface level into this to see, is this a crime or not? So that is that. And I apologize if I could just have a moment very quickly to go over my notes.
Sure. You want me to go back to Mr. Grill, and then I'll give you time to, or is this going to be quick?
You can go to Mr. Grill.
All right, Mr. Grill, I'm happy to hear any rebuttal, but I'd like specifically to respond to this issue of non-crime versus not guilty of a crime.
I've been tracking along, Your Honor. I've got some things prepared to talk about on that.
Okay.
First of all, I don't know where that's coming from. Respectfully, there is a difference between whether or not there's enough evidence to convict and there being not a crime. What the affidavit of Mr. Feeney shows is that there was evidence. What happened was that he had a witness lined up. He was told he couldn't use the witnesses he wanted. He had to go to find somebody else, talk to the new witness, and it quickly became apparent that this new witness was going to blow a hole in the side of his case. There were things that could have been done to address that. We could put Ms. Levinsky on the stand, get another witness, impeach her. The problem that results is then you have two DHHS employees talking past each other, and the likelihood of conviction at that point is pretty low. But that doesn't mean that there was no crime. Ms. Levinsky is entitled to her opinion, but I think what's apparent from the affidavit of Mr. Hall is that opinion of Ms. Levinsky is interesting, for lack of a better word, that she acknowledges that the manual says that there are these requirements, but she just kind of brushes past them and says, I think it's okay. And again, that's a thing that she can think that, I guess, but from the standpoint of that rendering it not a crime, I think that overstates it. What we get is we see the evidence from that was presented in the affidavit of Mr. Feeney. I'm looking specifically at paragraphs 3 and 4, where they're talking about what the students are telling the investigators, that they saw patients by themselves without any assistance from Hall. All of them indicated that they met with Hall once a week to discuss patients, but that they did not find him helpful or useful, or that he did anything to further their educational review of practices. Now, why that is significant, and this unfortunately, as I guess we do have to spend a little bit of time today talking about the healthcare provider manual, despite all of our best intentions to the contrary. But as we pointed out in our brief, there are two distinct theories of criminal liability that apply to Mr. Hall. There's the FFS theory and the MHP theory. And I think we did a better job summarizing them in the brief, but for purposes of a short form today, the MHP theory is what Ms. Levinsky is talking about. Because the MHP theory goes that the healthcare providers, the MHP, had their rules. And under the MHP rules for, I think it's United, Mr. Hall was not allowed to bill for student interns in 2020 at all. He didn't have the proper addendum, so whether or not he was giving them proper supervision at all was irrelevant. He was not allowed to submit those billings at all under the MHP rules. Now, Ms. Levinsky says, yeah, I know they've got their rules, but we don't really follow those. We think, that they can have supervised, student interns, which is why I think Mr. Feeney reacted with some matter of surprise on that, because it doesn't seem to be very consistent with the healthcare provider manual. But be that as it may, he's got this witness, she's going to say what she's going to say, and that he had to deal with that. The FFS theory is distinct, and that's the one that deals with whether or not the students are being furthered in their education. That's where it becomes significant about, okay, you're having meetings, but how are you supervising them? How are you furthering your education? This is a bit more of a subjective determination. It requires some evaluation of what's being done and whether that's really furthering education or not, which is why it has its own challenges from a prosecutorial standard. But that's an entirely different theory of criminal liability that doesn't depend at all on what Ms. Levinsky has to say, because Ms. Levinsky doesn't talk about whether or not once a week is good enough. She's only talking about whether or not supervised interns are okay under the MHP. So under FFS, that's where we could get into the idea, and this would have been an independent theory. And candidly, Mr. Hall, the statute of limitations hasn't run on that. That's still open liability for Mr. Hall if they decided to find new evidence that further supported the idea of whether or not that was actually furthering these students' education or not. So there's nothing here that shows that there was no crime, or that what Mr. Hall was doing was not a crime. It's just there were two divergent theories. Feeney went for the one that didn't require opinions. So he thought that was the MHP theory about whether or not he was allowed to bill at all for these student interns. But the FFS theory is still open and liable. So it's the idea that there is no crime, I don't think is supported by the record at all. Certainly the idea that no one looked at the regs for a year, that's absolutely not supported here. The evidence, what we have from Feeney's affidavit, is that there was rather extensive investigation, talking to the students, looking at the documents, talking with the healthcare providers, talking with Ms. Worsler, who worked for DHHS, talking with Trina Gee, who worked with the healthcare fraud division. There was an awful lot of looking at regs, and there was a determination made that there was enough evidence to support it. Again, prosecutors can be wrong, but that doesn't defeat the idea of prosecutorial immunity when that occurs. Nonetheless, I'm sorry, I lost my page here.
Take your time.
Talking about the Western Michigan film case that was cited by the plaintiff a moment ago, I think it's worth noting first that's an unpublished case. Yeah, I know the court knows how that works, but it's worth noting that on page 11 and 12 of that opinion, the investigator prosecutorial distinction is discussed explicitly, and they say that as the United States the United States District Court for the Eastern District of Michigan recently held in the federal case arising from this matter, defendant Metz was not entitled to execute prosecutorial immunity for his participation in the investigation that was conducted prior to criminal proceedings being commenced against the principles of the business transaction at issue here. Further on, they say, and defendant Metz was entitled to absolute immunity with regard to his decisions to arrest and prosecute the principals, including his participation in securing arrest warrants, as those actions were not investigatory actions, they were prosecutorial in nature.
Do you recall what the investigatory actions were in that case? I mean, I'll read it.
I'm skimming fast, Your Honor, but it seems like this was a rather extensive investigation of business transactions about who did what and exactly when. And it sounds like the prosecutor at some point, there was some, let's see here, defendant Metz, prosecuted the matter. The opinion, unfortunately, doesn't get into a lot of the detail of the facts, but it does state, in short, I'm just kind of skimming at the top here, there was a real estate developer who owned a building that was converted from a facility where aircraft was built to a condominium. Several units remained unoccupied. The developer sought an investor interested in buying units.
That's okay, I'll read it.
Yeah,
Too much.
it's a whole thing. But the point that I think is worth noting is that when the plaintiff says that, oh, it doesn't matter, if you're involved in an investigation, you're not a prosecutor. That's not what this case says. The case tracks with the federal court case that says that if you're acting like an investigator and you're doing investigator things, you're subject to the same qualified immunity that an investigator would get. But that doesn't negate or diminish your prosecutorial immunity for prosecutor things. So the decision to initiate charges, in this case, to arrest, all of that stuff, and in this case, particularly the decision to file charges, to prosecute them, and how they were going to be presented to the court, all of that is prosecutorial activity. And as the court noted earlier, what's the activity during the investigation that would have violated Mr. Hall's rights? If the investigators had done an investigation forever and never filed charges, there would have been no harm whatsoever to the plaintiffs. The only thing about what Mr. Feeney did that appears to be the subject of any controversy is the decision to file charges, and that's absolutely covered by prosecutorial immunity. Concerning Sampson and Massey, the plaintiff cites no law establishing a property interest in participation in the Medicaid program. That's a big deal, and that should be fatal to their due process claims and a number of their other claims as well, because if there's no property interest, then there's nothing to be taken away. Talking about probable cause, they say that, well, they should have known that there was no probable cause. This kind of loops back in with Feeney's side of it, but there was a waived preliminary examination. If Mr. Hall believed that there was no probable cause to support these charges, that was his opportunity to do something about that, to make the prosecutor put on his probable cause case. They waived it, which means that Mr. Hall is now very poorly positioned to say that Sampson and Massey, who certainly would have had less information available to them, should have known that there was no probable cause when Mr. Hall himself waived any determination about whether there was probable cause. Certainly, that his opportunity to be heard about the existence of probable cause was that preliminary examination, and so he waived it. Turning to gross negligence, I just want to touch on a point here that gross negligence is not the same as just being wrong. That's the whole point of it being gross negligence. It has to go above and beyond simple mistake, and it has to be a reckless disregard of whether or not injury results. That's a very high standard, as the courts have repeatedly held. So a normal, it's in a different circumstance, like a regular traffic accident is not going to be gross negligence. It has to be almost like I'm driving on the sidewalk with my eyes closed and I don't care if I hit somebody. That's the level of gross negligence that has to be met. And there's, as much as Mr. Hall certainly feels upset about the events that they transpired, none of the actors in this case really engaged in that level of recklessness. In fact, the record is absolutely devoid of anything that resembles recklessness. From the standpoint of Mr. Feeney, and again, he's covered by prosecutorial immunity, but if that, to whatever extent we're talking about anything on the investigative side, and we need to address whether or not there was gross negligence for that, he's talking to investigators. He's submitted his request through his supervisory staff, his chain of command, to get permission to file the charges, and that's approved. So there is not anything here of recklessness, shooting from the hip. There was deliberation, there was thought, there was care taken. So there is no recklessness there. And when we're talking about Massey and Sampson, Sampson was the one that worked in the Office of Inspector General. They reviewed what they had, which was there are criminal charges. Here's the base of it. Yep, that's what it is. And then once we get to Massey, who makes the ultimate, sign on the order that this is a suspension, she's relying entirely on Sampson's report. Again, where's the recklessness? Massey, as the directors, is entitled to rely on the information that's being presented by their investigatory staff. And Sampson is, looking at the records, making the determination of, yes, there are criminal charges. The idea, they want to move the ball here and say, well, you should have looked deeper and found out whether or not the actual charges were supported by the evidence. But that's too high a standard when we're talking about whether or not to suspend someone from participating in Medicaid program while they're under indictment for Medicaid fraud. I mean, it's really low bar there at that point to say, while you're being charged with Medicaid fraud, we're not going to allow you to participate in the Medicaid program. That's in any event, we're definitely not talking about recklessness of the type that would be required to reach the threshold of gross negligence.
Is the plaintiff still under investigation?
I don't believe the investigation is closed. To what degree the investigation is ongoing, I imagine is probably more a factor of available resources and whether or not new information comes to light. But the best of my understanding is that the investigation has not been closed. I saw in the response that there's some reference to other further administrative proceedings. To be clear, that would be separate entirely and distinct from anything to do with the healthcare fraud division. That's
the way I thought it was your brief. It sounded like the prosecutor, Mr. Feeney, was still raring to go.
Mr. Feeney very much thinks that there was a violation here, but it's right now at this stage there's not enough evidence as demonstrated by his affidavit to pursue that, because it would require a kind of subjective evaluation under the FFS theory to evaluate whether or not these meetings with Hall and the students further their investigation. The students said no, but it's I certainly understand the hesitancy to bring a criminal charge on that basis, because you get into a lot of murky territory. But if there were a new evidence to come to light, like a secret recording somewhere or something, I imagine that they would pursue that. But I just don't know, like at this point, what else could come out, what new information could come to light that would revive or resuscitate the charges.
Well, it's not relevant to my decision in this case, but I would certainly suggest to them that if they don't have a case, at some point,
I mean, I think bait has pretty well been cut on this point, Your Honor. Like I said, there's nobody, I don't think they're beating the bushes looking for people. I think the idea would be, more to the standpoint of, they have what they have now, and if some point in the future, something else transpired, new evidence came to light, that they, I'm sure be willing to relook at it. But at this point, I could not imagine.
What I'm trying to say is, if I were to dismiss this case, and then it were to come back that more investigation happened and he was again charged, I mean, I'd want to know that was going to happen before I don't want to be surprised.
No, certainly, Your Honor. I would say that
after the fact.
Certainly, I would say at this point, especially after this lawsuit's been pending, in the interim, and that nothing further has happened since that time, I think that's a good indication that we are basically where we're going to be unless and until something new were to develop.
Okay, all right. Mr. Savage, you had something else? I'm sorry, are you done there, Mr. Grill?
I believe that's it, Your Honor, unless the court has
Okay.
additional questions for me.
No, I don't. Mr. Savage.
Yes, and I will be very quick here, as quick as I can be, sorry. I'll just say that, yeah, if you talk to my client, he is very paranoid. This was a trying time for him that continues, and with the administrative process, as far as he's concerned, that is born out of the same, complaints, from two disgruntled former employees, as he believes that this case was born out of. He thinks that there's just people after him, and that the state is really after him now, basically, because of the continued persecution. I agree that when there's no crime, the investigation should stop. And here, I think that it's very clear that if there was a crime, it would have been discovered by now. Mr. Hall is innocent until proven guilty. I don't think that it's kind of the motion was kind of written with that in mind, but it's absolutely true. He is innocent until proven guilty. And so where you've got this kind of in-depth analysis of regulations, again, he's not been convicted of any crime based on those regulations. He is innocent of that. And so the Mr. Feeney's personal feelings, which I think absolutely would be influenced by his kind of investigatory bias, are not relevant here. And what is relevant, I guess another way to say that is that the immunity applies when the law is confused, not when the law enforcement is confused about the law. That is not when the immunity applies. And just getting back to the Metz case, I believe Your Honor was asking kind of what were the allegations, and there are let's see, A through F, so 6 of them that are listed on page 3 of that case. But the ones that I think would apply here are the basically the way they worded it in their complaint was making false and misleading statements to magistrates to induce the magistrates to issue arrest warrants, and then let's see, misrepresenting to the court that issued the arrest warrants that the plaintiffs there had solicited a false appraisal from to raise the value of their appraisal. But here, there were warrants obtained and there were items taken. And so that is the kind of one-to-one link there as to what the investigatorial misconduct would be. I believe,
Did Mr. Feeney sign the affidavit for the warrant?
Sorry, that'll be Mr. Grill will have to answer that, or Discovery will have to reveal that. But
okay, you don't have an affidavit.
Right, yeah. But as far as the just wanted to read really quick that there's a case, Vanderhoof versus Dickinson in the Sixth Circuit, where it was stated that a case need not be on all fours with the instant fact pattern to form the basis of a clearly established right. And an action's unlawfulness can be clearly established from direct holdings, from specific examples describing certain conduct, or from the general reasoning that courts employ, that a court employs. And so here, I don't think you can say, well, this wasn't a crime, but there's never been a case holding that this wasn't a crime, of course, because that just opens a Pandora's box to endless possibilities of things that you can charge Scott Hall with, and that you get that get out of jail free card.
I'm not inviting you to respond to Mr. Grill.
Okay.
I mean, it was his motion. I just knew you had something else you wanted to cover. Have you covered it, or is there something else?
There's just one more thing, and then
Sure.
I am done. Sorry, actually, it is a bit of a response.
That's all right. Come on. We're here to finish.
Okay, that there's no maliciousness, or no recklessness displayed, because that would require something tantamount to driving on the sidewalk with your eyes closed. I just wanted to say, I believe that's what this was. This was prosecuting with your eyes closed. You had the regulations right there.
But he's got an expert. He's got an expert from his own experience who's going to testify this was in violation of the statute. What faith there?
Well, sorry. So again, it didn't take the expert a year to get back to Mr. Feeney. It took Mr. Feeney a year to check with the expert and just say, the most important kind of foundational thing. By the way, is this a crime? And they got back to him and gave him an unequivocal answer to that, which was no. And so that is the. I wouldn't expect there to be, a whole class of, people that are charged with non-crimes, but I do believe that makes him a class of one here, Mr. Hall. So that is my conclusion.
Thank you. Mr. Grill, you get the last word if there's anything else you want to respond to.
I think just very briefly, Your Honor, I just want to make it abundantly clear. There's trying to avoid smudging the timeline here, but when we're I think the court noted when Mr. Feeney was prosecuting this, when he was, as this case developed, in paragraph 30 of his affidavit, he talks about Michelle Worstler, who works with the Office of Inspector General at DHHS, had provided him with testimony in the past.
Right.
And then he also refers to an analyst, Trina Gee, with the Healthcare Fraud Division in the Attorney General's office, and that these were, in Mr. Feeney's opinion, the foremost experts on the Medicaid program relating to fraud. These would have been the people he was talking to. He was not allowed to use Ms. Worstler due to DHHS determinations, and he was directed to somebody in the policy wing, and that policy person was Ms. Levinsky. So that's when he had to talk to Ms. Levinsky. It wasn't because he finally got around to thinking about what the regulations might be. It's that he had to find a witness that DHHS would allow him to call, and that's a different problem. Certainly, it doesn't support the idea of a lack of care or concern.
Very good. Well, thank you both. I appreciate your time. I'm not going to issue a ruling right now, but I'm going to think this through. I'm working on an opinion as we speak. I hope it won't take too long, but I can't promise you a date certain at this point, but we're moving on it, okay? And I'm going to sign off now, and we'll conclude, and then you gentlemen can let the court reporter know if you want to order at this time or wait, all right? Thank you,
Your Honor.
Thank you,
Madam.
Thank you. No, I mean, I guess not at this time. I would like to order. I guess I'll just reserve that right.
Right. I think we'll wait. Once the court issues its ruling, probably one or the other of us will probably order a transcript. But
Okay.
Thank you very much.
Thank you.
All right. Have a good one.
I am.